hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us as we are covering Florida versus Courtney Clenney. This was a motions hearing from 12/18, which was yesterday, December 18th. Today is the 19th. So we are going to cover the latest hearing that happened yesterday. So welcome in everybody. Granny Debbie, good to see you. Thank you for coming on over. Richard in the kitchen. He was first in our chat. Good to see you, Richard. Hey, Joy, good to see you. Green-eyed cat, welcome in, Alice. Jaded Wonder, Mary, good to see you. David Robinson, switching over, joining us from our Shauna Gardner, and Mario stream we just did. Seashell, good to see you. Work slowed down, very good. Joyce, good to see you. Thank you for joining us. Kathy Davis and Selena. As Roger's jumping down. Crazy Mary Jo, Kathy Davis, good to see you. Got to another like for here. The former Steno, good to see you. Thank you for joining us. Hey, Allie C. and Carolyn, good job for finding us and joining us. Appreciate that. Sometimes notifications don't always work, I guess, right? So, all right, you guys, let's get to it. Let's just jump right to it. So Florida versus Courtney Clenney. So if you guys aren't familiar with this happened. We've done a couple deep dives on Courtney and Christian. So if you want to go check out our playlist, you can get up to speed there. But again, here's a trial that was supposed to start December 2nd, just like Shauna way back when. She was going to be December 3rd, and that got kicked out in the summer. Courtney was supposed to start December 2nd of this year. And now this has been pushed out again. So this happened April 3rd, 2022. And we've gone over, like I said, we did a deep dive on her arrest out in Las Vegas. And you know, there's a couple, we did her interrogation, or not her interrogation. Well, I guess it was her interview with law enforcement after she stabbed Christian. She claims he was coming at her. She claimed self-defense. She threw the knife at Christian, caught him in the chest, and he passed away a few hours later. So that happened April 3rd of 2022. She wasn't arrested until August 10th of 2022. She was in Hawaii. She went to Hawaii, and I believe she was in rehab. I think. I don't want to spread any false rumors, but I'm pretty sure she was over there for that. So anyway, she was arrested there, and this happened in Miami, and then she was in Hawaii when she got arrested. So they have a long history of domestic violence. This could be like Amber and Johnny. This could be like Sarah Boone and Jorge. It's going to be one of those cases again of a long history of DV. So, all right. Yes, David. This couple, they did like to fight. They did like to fight, that is for sure. JMS, yeah, the difference is really, it truly is unbelievable. Yep, agreed. Hey, Lily Wayne, good to see you. Hector's mom, thank you for joining us. Iowa Backyard, Shirley. Grampy, there you are. Yeah, we're starting a little early because Shauna and Mario ended. So we are starting a little bit earlier. So Linda, good to see you. And Becca, thank you for joining us again. So, all right, let's get to it. Nan, good to see you. All right, so this is from yesterday. So let's check this out. Get myself set up here. I may have to make myself a little bit bigger. All right. All right, so again, this is down in Miami. There's no closed captioning on. Oh no, there is closed captioning. Okay, let me put the closed captioning on. Okay. Here we go. So this is from yesterday.
That happens plenty. This is the defense's motion to dismiss based upon Youngwood case and Brady. I know the court's I think the court had an issue with something of this nature maybe a year ago, so I know the court knows the case law very well. I'm not going to beat a dead horse as to what the standards necessarily are, but under Youngblood, we have to show the destruction of evidence, whether it was exculpatory, and if not exculpatory, whether it would be useful to the defense. And if it was just useful to the defense, then the court has to conduct an analysis into whether or not the state acted in bad faith. In this particular case, there is a collateral proceeding that has been taken, that has been lingering in the civil division for quite some time. In that particular case, the plaintiff and other defendants in that matter have been conducting discovery, and during one of the discovery depositions of I always want to say Danny, I think it's David, Mr. Del Valle, who was the residence liaison and managed the spa at the One Paraiso condominium where Ms. Clenney resided with Mr. Obumseli. He was familiar with the two of them, and he was actually the first one, and this is clear in video provided by the state in their discovery. There's elevator video that shows Mr. Del Valle entering Ms. Clenney's apartment prior to the arrival of the police, where he encounters Ms. Clenney holding on to Christian Obumseli, begging for help. This is after she had called 911. The dogs run out of the apartment. They are covered in blood. And Mr. Del Valle is seen with another security guard, Ms. Ormeal, entering the apartment. Ms. Ormeal never entered the apartment, but Mr. Del Valle is shown entering the apartment. And during the elevator surveillance captures Mr. Del Valle videotaping and clearly taking pictures. One of the civil attorneys was able to scrape a video, I believe, off of some form of social media that clearly showed that it was Mr. Del Valle that had taken that video. Because you can see his shoes in the elevator match the shoes of the person who was in the apartment that had taken that very brief video that again shows Ms. Clenney clutching Mr. Obumseli in her arms. Mr. Del Valle at that deposition then went on to testify. When confronted with, well, we found this one video, where's the rest of it? Because other surveillance video provided by the state shows him snapping away and videotaping as fire rescue is stumbling around trying to get Mr. Obumseli out of the apartment. So, Mr. Del Valle then testifies, well, an officer told me and stood over me and made sure I deleted all my photos and videos. Clearly one of them survived. It was on social media. How exactly that happened, Mr. Del Valle denied circulating that, but that's what we have. We have surveillance video provided by the state of Florida that shows Mr. Del Valle taking all these photos. And actually Mr. Del Valle testified that nobody from the state ever spoke to him. They never did a pre-file with Mr. Del Valle, despite them having possession of surveillance video showing him taking this video. Right? What they should have done is, hey, Mr. Del Valle, come to the state attorney's office, right, which is the procedure. We need to do a pre-file with you. He was the first one to enter the apartment minutes before law enforcement. They had possession of the surveillance video that shows him videotaping and taking pictures, because that was provided to us on September 3rd of 2022. And they never, that deposition, forget the date, but that deposition was taken I just took the excerpts, but it was probably about 3 or 4 months ago. And so, constructively, at a minimum, the state was aware of this witness. They should have been aware that he was taking videos and photos. It was depicted in their own video they provided us. And they had never, as of the date of that deposition, said he's never spoken to anybody. Again, going back, he testified under oath that an officer made him delete everything. He was questioned by the other attorneys, defense attorneys, during that deposition, by the plaintiff's attorney. I asked him very few questions, but I asked him if he knew the officer's name, no idea. Whether he was in a police uniform or in plain clothes as an undercover. He indicated it is a police officer that was in uniform. None of the body-worn camera that the state has provided to us has shown that, as far as my review goes. Yet, as in any homicide scene, there are so many police officers responding that have either the body-worn camera has not been provided in discovery of all the police officers that are listed in discovery.
Let me just stop you real quick.
Sure.
To make sure I heard you correctly. You're saying it's possible that not all of the body-worn camera has been turned over, or that it is your belief that not all of it has?
It's just obvious it hasn't all been.
Okay.
Now whether or not...
I'm sorry to interrupt. Can I ask how or why you believe that?
You'll have a chance to respond. Make sure you make a note of that so that you can respond to it. I just wanted to make sure that I was hearing you correctly.
Sure. The only way it's not possible, in my opinion, based upon the video surveillance that I watched, was whether it was we have the responding officers, the two first that entered the apartment, Carvalho and another Latin-named officer. We have another officer or detective that was running around taking notes. We have another one that was standing outside. And in those body-worn cameras that we have been provided, there's maybe 6 or 7, 8, 9, 10 other units that responded. And we don't have those. So, that needs to be investigated by the state as to what other body-worn camera, because they're saying, well, there's no evidence this occurred, that Mr. Del Valle was standing there and an officer deleted it. I don't know what motivation Mr. Del Valle would have to fabricate that. So, as in any crime scene, there's so many officers running around that whether they had their body-worn camera on or not, I can't say for certain. But there's clearly officers that responded, and I'm going off of what Mr. Del Valle said, that it was an officer in uniform. There's definitely body-worn camera, if it was on, that of officers that have not been either listed or have been listed but no body-worn camera has been turned over. So, regardless, going back, the state should have been aware of this because it was depicted in the videos they provided. They never spoke to Mr. Del Valle. On Mr. Del Valle's testimony under oath, he testified that an officer told him to delete it. So clearly, and it's in my motion, Judge, we're not saying this is materially exculpatory. I can't say that. We cannot allege that. And the standard for whether it's potentially useful, sure, it's potentially useful. It would have shown the scene untainted, so to speak, by the fire rescue personnel, the officers that responded. It would have shown the pristine, quote-unquote, crime scene. So the burden to say it's potentially useful is there. I believe it's there. So the more difficult part is what Mr. Abhoff says in his response was their bad faith. An officer's training, at a minimum, would clearly be, you don't destroy photographs and video of a crime scene that was taken before you even got there. I mean, that's textbook police training 101. The second part that I think shows bad faith, and again, so the standard thing what Mr. Abahoff says is, if it's just negligent, that's not bad faith. But this, an officer who's trained to preserve evidence, this is not just an oversight, this is not just negligence. It's an intentional act committed by an officer who, yes, is unknown to me at this time. But this is intent to destroy evidence, which would be potentially criminal, quite honestly. It shows bad faith on the part of law enforcement and the government. In combination with the state never taking any action to conduct a pre-trial conference with one of, I believe, the most essential witnesses in their case, the person who entered the apartment before the police even arrived, who is clearly on surveillance video provided by the state, taking photographs and evidence in the form of videos and photos. So that combination of things, I think, gets us past the potential, well, it's potentially useful, and then that puts us in the category of the government acting in bad faith. So yes, dismissal is one of the most onerous actions that a court can take. But in combination, although I don't necessarily believe it is a factor under Youngblood, but the combination of all these factors, in combination with prior misconduct on the part of the state, and I do include this in my motion, the rule of professional conduct that we all had as prosecutors, in one of the footnotes to 4-3.8, is that prosecutors are ministers of justice. They shouldn't secure a conviction just to secure a conviction. They're gatekeepers of the justice system. And if they're not acting in good faith and carrying out their oath as a prosecutor, I think that goes to the bad faith and the intentional destruction of evidence. They had this video of a person taking photos and videos of a pristine crime scene. So I think that they can't hide behind, well, we didn't know, or we think Mr. Del Valle is a liar. The evidence that we have here is his testimony under oath saying that he was instructed to delete that. So I think that this does rise to the level of a Youngblood, possibly even a Brady violation, but I think that when we look at everything that has transpired in this case, plus what we have here, that the court should consider dismissal.
Thank you, Mr. Campbell. Mr. Abahoff?
Yes, Judge. So defense does not discuss too much as to the materially exculpatory aspect of this. They concede and they move to the second standard of this. The problem with moving past this would be that you have to look at whether or not, when you're deciding whether something's material exculpatory, whether other items exist that would cover this. So there is that testimony, and it's clear it is not material exculpatory. But more so than that, not only does this testimony exist, but that video that the defense discussed also exists. It shows this person, Del Valle, coming into the apartment. It shows the victim in the arms of the defendant. It shows everything that the defense wants to be able to use. So the problem with what defense is saying here today is they had an opportunity to cross-examine, to depose this individual, and that's where all of this comes to light. He is shown this video and does not make any indication that there are other videos. He does not say that there's anything other than this video that is what is depicted. What is clear, though, is that in this deposition, he says that he is taking pictures with an officer standing by. And what all of the video that's been provided to the defense, that is a part of this case. The only time that officers are standing by is after the victim has been taken out and is transported to the hospital. So it would have been pictures that are depicted in CSI photographs, crime scene photographs. At that time, that's when it's alleged that this officer, who has not been identified, has never been identified, comes to him and says, hey, you need to take this off your phone. Mr. Del Valle, and what is ignored by defense, is he's also asked, well, why is it that we're hearing about you showing these items to someone in valet a year before your deposition or a year after the incident? So that's why the state, in their motion or in their response, calls into question the credibility of this person. Because he does have incentive, because he's being called out for doing things he is not supposed to do and being in possession of these items after the fact. He then says, when asked, well, do you still have these items? He said he got rid of the phone. And a major component of this analysis is the actions attributable to law enforcement or the government versus a private citizen. And Mr. Del Valle has made clear that he had himself, by getting rid of his phone, has gotten rid of these items. So what the defense wants to attribute to the government, they can't. They can't. They can't say here today any aspect of the actions of that officer, even if taken as true, for purposes of this hearing, were in bad faith. Were nothing more than his job of securing a scene. All they put forth before this court is Mr. Del Valle's deposition, and in there's zero aspects to the mental status of this officer or why things are done. When it comes to conducting pre-files, again, outside of the state talking to people, trying to collect evidence, there is no, and the case itself is, I mean, it's I have it here. No, it's Youngblood itself. You know, the U.S. Supreme Court has rejected the idea of imposing on police an undifferentiated and absolute duty to retain and to preserve all material that might be of conceivable evidentiary significance in a particular prosecution. They want to speculate that the state, in not doing this pre-file, was acting in bad faith. But that's not enough for them to meet their burden in this hearing today. So when it comes down to their burden in showing bad faith on any government actor, they cannot do it. And they cannot definitively show at all that the actions of, even if these items existed, their destruction was not done by a civilian versus a government entity.
Anything further from the state?
No, you're not.
I'll hear a response.
Judge, the state's response is fatal in certain aspects. Their own video surveillance. So they're saying, oh, Mr. Del Valle said the police were next to him the entire time while he's taking the videos. That is false. Well, Mr. Del Valle may have said that, but video surveillance provided by the state indicates that is 100% false. There's a camera on the elevator that shows the dogs running out, Mr. Del Valle entering the apartment. And later on in that video, yes, there's surveillance video of him photographing and videotaping fire rescue as they are trying to get out of the apartment with Obumseli in tow. They had to get a sheet. He was a very big man. They couldn't fit him in the gurney for whatever reason, so they were pulling him in a sheet. And he's sitting down, crouching down and taking photographs and video. But again, police were there at that moment. But the first part of the surveillance video shows Mr. Del Valle going into the apartment, and we know he was inside the apartment because of surveillance video from the elevator provided by the building. You can see his shoes, and the video that was scraped from some social media from another defendant in the civil case shows the same shoes. And again, the scene where Ms. Clenney is clutching Mr. Obumseli in her arms. So that argument that though the video was there and it would show the same thing fails. As far as the Youngblood, the might portion, Again, Mr. Randall, talking about the pre-file procedure, I can't think of any more important witness than the first person on scene, prior to law enforcement, who was taking video and photographs. I can't find anybody more important at the first investigative phase. Maybe Mr. Anhoff wants to throw the lead detective, Detective Briseno, under the bus because this is a botched investigation from the beginning.
I'm going to object.
Okay.
I mean, it's speaking for me.
Yeah, no, thank you.
But Detective Briseno, apparently in any reports, so I didn't interview him or provide it to the state, so maybe that kind of lets him off the hook to a certain extent. But then the state being in possession and having knowledge that Mr. Del Valle was the first one there, clear that had to have been reported to them. And then them having the surveillance video, this goes beyond negligence. This is something that they should have spoken to, gathered the evidence, and they still haven't spoken to him. That boggles the mind. So this isn't just negligence. Some form of bad faith has to be inferred here when they've had the opportunity to get this evidence, which now who knows where it is, whether it exists or not, and they did nothing except destroy it. According to Mr. Del Valle's testimony, the police ordered him to destroy it. So I believe that based on all of the totality of what occurred here, specifically with this potentially useful evidence for the defense, rises to a young blood violation that would allow the court to dismiss.
Thank you, Mr. Prieto. Now let's go ahead and proceed with the motion for reconsideration of bond. I'll hear from the defense.
Yeah, if I could just have 1 minute, Judge.
Do you want to take a break?
We have before the court defendant Courtney Clenney's second amended motion for reconsideration of bond. I'll just start out noting the court's concerns. I believe when we filed this court is not sitting in an appellate capacity as to Judge Cruz's rulings. We recognize that, and we're not asking the court to view this as some type of appellate procedure, questioning Judge Cruz's prior rulings. But what we do have, I believe, is significant new evidence. The evidence that we have is now, again, in a collateral proceeding, the civil wrongful death case. One of the co-defendants, First Service and One Carrizo Condominium Association, hired Dr. Malad Webb to review all the pertinent findings by the medical examiner. In this case, they hired Dr. Webb to review the video evidence in this case that shows the condition of Mr. Obumseli upon the arrival of the police. He had also reviewed a snippet of the video taken by Mr. Del Valle, which, by the way, this kind of comes to play with our prior motion, but that video snippet is about 3 seconds long. That's all that was able to be scraped. But Dr. Webb reviewed that. In fact, Dr. Webb's expert report is attached to the motion. So he lists in his table of contents at the end, starting on page 16, he lists everything that he reviewed in this case. I'm not going to read it all because it is lengthy, but the court can review that later. Again, this report was provided to the state. The poignant findings. Well, let me give the court a little context, which it's in the written motion, but I'll try to be brief because I know you're on it. So, at the Arthur hearing, the state, when providing the evidence that they thought was useful to the court in finding proof evident presumption great to second-degree murder, presented evidence that they thought was, quite honestly, I don't know what the other prosecutor was thinking, but there's evidence that Ms. Clenney was on the phone with her mother at the time of the injury in this case. The 911 call made by Ms. Clenney at 4:57 p.m. was immediately after she hung up with her mother. There were 2 calls to her mother. The exact times I don't remember, but I believe it was 4. It was the first phone call of 6 minutes. We believe the call dropped. Ms. Clenney immediately called her mother back, and then that call is approximately 7 minutes. And then, again, within 30 seconds to it, you can't tell because the Verizon wireless phone records show 14:57, the 911, 14:56, but it doesn't have the seconds to it. So, but we believe the evidence shows that Ms. Clenney hung up with her mother and immediately called 911. Our argument was within seconds, 30 seconds or so of the injury. The state believed and presented their argument that the injury occurred while Ms. Clenney was on the phone with her mother on the first phone call, and that basically let him bleed out for, I think they argued, 12 to 14 minutes, something to that effect. And why is this relevant to the motion for bond reconsideration? It goes to whether this is a second-degree murder or a manslaughter, which the court can review with this new evidence, the proof evident presumption, great aspect of Arthur. But yes, after that reconsideration, the court also needs to review the factors of pretrial detention, which are, risk of flight, danger to the community, and whatnot. That's a secondary. So whether or not this changes proof evident presumption great per second, it really goes to later on, which the state argues that she's still a danger, right? Never mind this new evidence. Nothing that doesn't change the calculus of whether or not she's a flight risk or a danger to the community. But it does. A manslaughter is a bondable offense. It's still an enumerated dangerous offense where the court still needs to make findings that she's not a danger to the community or a flight risk. And we also have new evidence about the flight risk, mainly the financial component of whether it is pointedly stated in my motion. She's broke. I mean, that's the most precise legal term I can use. She's broke. So, going back to why this expert's opinion is so important. To prove, a second degree, they have to show depraved mind and coupled with inaction. Manslaughter is reckless. I'll get into that a little bit later. But this forensic report by Dr. Milad Webb, in his medical expert opinion, he's a medical examiner in Tampa, currently. He was an Army medic. I believe he was a doctor already, serving in the... No, I apologize. He was a nurse or medic in the military. He's treated injuries to the subclavian artery previously, his experience with these. So he has experience with the precise injury that occurred in this particular case. Dr. Webb, through his medical expertise, was able to calculate the blood flow of the quantity or volume of blood that goes and travels through the subclavian artery. He then, obviously he examined all the medical examiner photos, and in his opinion, based on blood flow calculations, based on the evidence that the state has, mainly the 911 call of Ms. Clenney, Mr. Obumseli can be heard speaking in the background, saying he can't feel his arm, he can't feel his arm. Coupled with the video taken at the scene and the condition of Mr. Obumseli at the time of the arrival of the police, he's able to extrapolate a percent of the volume of blood loss that had occurred. And in his expert opinion, he says the injury occurred between 16, military time, it was 4:51 regular time, 4:51 to 4:57 p.m.
PM.
Correct. And again, it's not, I think it's in my motion, but the 911 call from Ms. Clenney was at 4:57 p.m. So, reviewing everything that the doctor reviewed, his opinion is 4:51 to 4:57 p.m. the injury occurred, but it's more likely that it occurred within seconds or 1 minute of the 911 call. And that is important because the state's theory at Arthur that this is a second-degree murder is eviscerated. I mean, that would show anybody who lets somebody just bleed out for 14 minutes before they call 911. The actions, that shows a depraved mind. What this shows with this new expert evidence is that at best, this was reckless conduct, and Ms. Clenney called 911 right away, trying to save Mr. Obumseli's life. Right? We also know he was in her arm, and she's trying to stop the bleeding, which is why she was covered in blood. So this changes the calculus of this being a second versus a manslaughter, and that is supported now by reliably scientific evidence. So the state, and again, we understand this court is not sitting in an appellate capacity, but this court can't just say, I'm only focusing on this new evidence. The court still needs to see the entire picture, which is why there's all the information that Judge Cruz did have, but it is contained in our motion, because the court has to make a finding on whether granting or denying bond based on everything, not just this new evidence. So all that background is there. Again, we have, which was partially presented to Judge Cruz, the world's most renowned battered spouse syndrome expert, Dr. Lenore Walker. We have the knife throwing expert showing that the knife can be thrown. There's all these factors that change the calculus of Ms. Clenney's innocence, or again, at best, never mind the self-defense. This new evidence shows that this is a manslaughter. Obviously, again, subject to the statutes and 3.131's factors that the court has to consider: risk of flight, danger to the community. So talking about that, the state has doubled down in their response, saying that Ms. Courtney has violated previous court conditions because she had a DUI in Texas and traveled to Nevada. But the state is ignoring the affidavit of Gene Antis, who was Ms. Clenney's attorney in Austin, who gave us an affidavit for the initial ARPA hearing, going through his representation of Ms. Clenney and opining and stating under oath there was no conditions of her bond that restricted her travel. She did not violate a court condition. There was one time when actually Ms. Clenney was on the way to enter a plea on her DUI with Mr. Antis, where Mr. Antis met with her in the hallway of the courthouse and determined that she was extremely inebriated and that there was no way she could enter a plea. a willing, knowing, and voluntary plea, and so she did not present herself to the court. But he then moved to have her sentencing reset after she did not appear. And that's all in his affidavit. So, and I believe it's in one of the last paragraphs. It's clear as day. He says Ms. Clenney did not violate any conditions other than discussing the inebriation that he thought she could not proceed. So that is again not factual the way the state reports to her failure to appear or abide by prior conditions. So speaking to her risk of flight, again going back to the prior state's arguments that Ms. Clenney has millions of dollars to flee the jurisdiction. That calculus has changed. The state again tries to rely on a transfer of just over $1 million, I believe it was, that Mr. Clenney, Courtney's father, initiated. The state liked to classify that, and this is the motion for another day, but in an affidavit for a warrant, they claimed that transfer was some type of fraudulent transfer to hide funds. But if the state would take off their prosecutorial blinders, it's nothing more than a father securing his daughter's finances so he can manage her finances while she's sitting here in handcuffs in an orange jumpsuit. And Mr. Clenney is happy to go under oath and explain to this court that Ms. Clenney has nothing. And it's been a hardship not just on her, on Ms. Clenney obviously, but on her family. The finances are clear, and the state likes to call me out and say I presented no evidence. Well, let me just say, I'm not going to put anything false into a plea. And the state says I have no evidence. Well, last night, I have, what I could gather between last night and this morning, I have the foreclosure letters from a law firm on her home that she is in default. And I would also have Broadway Bank notice of closed account. She actually has a negative balance of $3.1026 that they were kind enough to charge off. So at least she doesn't owe those $300. But that's her notice of closed account. And again, Mr. Clenney is happy to discuss. I think it would require, or should be, an in-camera hearing with the court, and we don't mind if the prosecutor's there, but I don't think discussing her family's financial condition is something that I'm going to speak to on the record. But it is all accounted for, and Mr. Clenney is happy to go under oath to discuss these things. She is correct. She's got no money, and I'll pass this up to the court if I may. I guess we could just mark this as defense. Are we one or A? Defense composite A. I'll send you that. I'm sorry, I'll send you that.
Defense Exhibit A1 record identification will become State's Defense Exhibit A.
I think it would be that over no objection.
No objection.
So, Judge, obviously, look, this is not a narcotics case. This is not a fraud case where, the source of funds and where did the funds go are kind of, Pete's judicial antennae or prosecutor's antennae when there's transfers between accounts. But again, the transfers were solely for the family to be able to manage their finances, which are depleted completely on attorney's fees. The family had to pay her mortgage for the last 3.5 years, which caused a great financial burden on the family. It is now in foreclosure. There's actually a potential for a deficiency judgment against Ms. Clenney. She has no funds, which goes to the court's analysis of risk of flight. Obviously, can support themselves. And the state at I think, several hearings has made the argument that Ms. Clenney can fly to, let's say, Morocco, a non-extradition country, and start up her OnlyFans page again and make millions. That's just, I find that to not pass the lab test. Ms. Clenney has all her family in Texas, the ties to the community, and again, there's no funds for Ms. Clenney to go anywhere. So the new information that the court needs to reevaluate her risk of flight is met. There's new evidence that the court can evaluate. And just going back to the manslaughter versus second degree, under the pretrial detention statute, the state can't present evidence sufficient to meet the standard for second degree, but they at a minimum it's manslaughter. So the argument by the defense, and I just have a short, I promise I'll be quick, Judge, on a little PowerPoint here, just discussing a couple of those things. But I believe Ms. Puglisi, my better half, through the 3.5 years that we've been together on this case, wanted to address the court on one issue that she made.
Certainly. Judge, I just want to speak to the misconduct for a second and the delay. And the reason it's important is because Courtney's been in custody now for over 3 years. And 18 months of that has been a delay, not a delay by the defense, but a delay by the state based on their misconduct. And it's not a belief of misconduct that we've alleged, but rather a misconduct that the court, Judge Cruz, actually found. She found not just one violation of misconduct, but 2 violations. And so once those violations were found, and honestly, it's for something so sacred that we as defense attorneys take, which is attorney-client privilege and work product. You know, we work very hard to defend our clients, and we do so believing that the state attorney's office will uphold their oath. And what we know is that Attorney Khalil Quinnen looked at emails, and the second violation, which I want to speak about, the one which I think is more serious, is the fact that he looked at a privileged email that I wrote to the family. Attached was a email that said, or excuse me, a Word document, which was a bullet point of things to do to prepare for her case. It was titled confidential, and not only did he review it, but he forwarded it on to law enforcement. What's important about this is the timing of it, because, and I believe this to be correct, I don't have the dates in front of me, but that second violation that was discovered came after the motion for reconsideration of bond. At the last motion for reconsideration, we did allege the misconduct, and at that time Judge Cruz had found that there was misconduct, and so that was fine. But she didn't know about the second one, which was later discovered, which is even more egregious in this case. And so I think that the court should take that into consideration, because as a result of the misconduct, we were forced to have to file motions to recuse. And the reason we had to do that and delay preparing the case is because you can't prepare and do depositions and with prosecutors who have committed misconduct. So while they may have wanted us to continue to prepare, we couldn't do anything. And so she has languished for an additional 18 months, which this case could have been tried over 18 months ago. And so I think that the court should take into consideration not just that misconduct, but the delay that it caused. And it's not us alleging it, it is a proven fact found by Judge Cruz. Thank you.
So, Judge, to wrap up kind of the analysis before I just do a quick PowerPoint, obviously the court needs to consider, right, the protection of the community, risk of harm to the community, risk of physical harm to persons, and under 903.046 are the conditions the court is familiar with when determining bond. Just briefly, the defense has to the community, but Ms. Clenney, the plan would be for her to return to Texas, where she has her family. If necessary, we could find her a place here. But Ms. Clenney does not pose a danger to the community. One of the issues in this case of this tumultuous relationship between her and the decedent, it was a drug and alcohol-fueled relationship. Mr. Obumseli would purchase narcotics for her, use narcotics with her, and it was quite the toxic relationship, more so when the parties were inebriated. Ms. Clenney had a very severe drinking problem. Drugs lesser of a problem, it was more than alcohol. And that, when Ms. Clenney was obviously, there was a delay in arrest. I believe the court's familiar. This incident occurred on April 3rd, 2022. She was not arrested until August of 2022, 4 months later, where she was in Hawaii seeking treatment for her alcohol disorder and for PTSD. And again, during that entire gap between her arrest, I was in touch with the lead detective in the state attorney's office saying, hey, if there's going to be a charging decision made, we will self-surrender. That they wanted, whoever's decision it was, we're going to go send a SWAT team to go pick up the young lady who's in rehab using SWAT and helicopters to conduct surveillance. But again, those actions, not just by myself, but by Ms. Clenney, shows that she's not a fighter, she was seeking treatment, and she's been in, as Ms. Puglisi was saying, she's been clean and sober, thankfully, for over 3.5 years now. And if there's a concern of the court about usage, she can be tested. She can have, what do they call it? Is it a scram? They change names. I don't know what the acronym now is on what they're using. She could be put on an alcohol testing device. But again, you're looking at the factors of 903.046. She's not a danger to the community in general. She had a DUI. She had a prior domestic battery in Las Vegas, where it was Mr. Obumseli who was the alleged victim in that case. Those charges were dropped. I'm not going to get into the details of that case, but there's a lot that went on there. But again, it was dropped. There was evidence that her hair was on the floor. Ms. Clenney's hair was on the floor in the hotel room. But she's the one that got picked up trying to cover for Mr. Obumseli. But in general, she's not a danger to the community. And I think it's relevant, and we can just go through the PowerPoint in considering. And why I'm going through this, Judge, I think a person who's committed a second-degree murder versus a manslaughter, right? We have the depraved mind versus reckless conduct. And I think that's a significant difference. But again, as the state points out correctly, these are still both dangerous crimes, and the court has to go through a subsequent analysis prior to granting bond, even though manslaughter is a bondable offense. So this is the elements that the state would have to prove. I would just point out element number 3, right? It's an unlawful killing, an imminently dangerous act, demonstrating a depraved mind. What we have here, looking at the new evidence of Dr. Webb, this is not an act that was demonstrating a depraved mind. Next. So just describing what's imminently dangerous is one of the elements. It is done from ill will, hatred, spite, or evil intent, and in such a nature that the act itself indicates an indifference to human life. And throwing a knife, at best, again, never minding self-defense, throwing a knife, I think, could be considered a reckless conduct, which would be a manslaughter. Next. Judge, we have a self-defense case here, and I know that Judge Cruz evaluated some of what we had as far as self-defense. Again, I would just point out the experts in the knife throwing that we have now, but I'll skip through the defense jury instructions. I don't think it's so relevant for the court's consideration now. So, Antoine versus State, and this is case law interpreting, and I think these were dismissals or JOAs, where the court found, again, in Antoine versus State, 138 SO3D 1064, that extreme recklessness or an impulsive overreaction to an attack or injury is itself insufficient to support a second-degree murder. So, if we have Ms. Clenney throwing a knife when there's an altercation with Mr. Obumseli, who in her statement testified to the police that he was crouching down in a manner where he's about to launch himself toward her as he had done previously in the lobby of the One Paraiso, it was an attack, and yes, throwing a knife, could it be considered an impulsive overreaction? Sure. But again, the case law shows that's not a second-degree murder. This is a manslaughter. Again, a bondable offense. So an impulsive overreaction, again, is insufficient to prove the ill will, hatred, or spite element of a second degree. Do that. This is fun. Next, we can, again, all these cases are interpreting second degree versus manslaughter. Again, overreaction, not a second degree, it's a manslaughter. Again, the elements they would have to prove for manslaughter: she intentionally committed an act, occurred the act, and the death was caused by the culpable negligence or recklessness of Ms. Clenney. Again, absent self-defense, this case is a manslaughter. Again, this is Manini versus Gillum, 477 SO2D 1015. This was, I believe, the judge removed the fact from the jury and only gave him the option of the lesser, if my memory corrects. But I can send all this to the court and I'll CC the state. Again, going to the flight risk, she has extreme ties in Texas. She was aware of the pending investigation. We were in contact with the government. She was getting treatment, as you can see here in the letter, where she was seeking treatment already. I believe this was in Hawaii, correct? So, and her financial status has changed. I mean, it's done a complete flip-flop of where she was prior to the arrest. She will continue receiving treatment if she is released. That would be a condition of her release. And the type of crime alone is not a reason to deny bond. Her criminal history is minimal, including the DUIs. And again, going to, I believe the statute does not allow you to release her on non-monetary, so we would ask for not a huge I would recommend a $100,000 bond. Monetarily is a challenge these days, but she can be put on GPS monitoring. There's the company that Mr. Obumseli found that can monitor her even in Texas and does monthly reports or weekly reports to the government. I think we have another slide. She should be ordered to continue an outpatient treatment. This is the company, EPS Monitoring, that they can, they have a really good, Sabrina knows a little more than I do, but they produce reports to the court, they can be checked in, and obviously they inform the court and law enforcement upon it, if she were to cut it off, for example, it would be immediately. So they work within the court systems. And I don't know if things have changed in Miami-Dade County. I just recently had a client in Alachua County that was put on GPS, and my concern was they wouldn't release him because how are you going to monitor him in Miami? Because he was a resident here. They're like, oh yeah, no problem. The way all the technology works now, my client was in Alachua on GPS being monitored here. No issue. So I don't know if Miami's come. I doubt it. But if they have that technology available, but if not, we have the private company that is willing to do it. Their mission statement. Now, this is also attached to the motion for reconsideration of bond. This was a case this was a Manatee County case. It was in the media. A young lady was a ballerina, dating or married to some wealthy individual, and police respond. She was shot. She shot the guy multiple times, right, facing second-degree murder charges. And in that case, which was a 2020 case, it was just resolved, I think, last year. She was actually convicted, but at bond, she was considered. She got a $100,000 bond. Not sure what that thing is. So maybe another charge, ROR, but no contact with victim, no firearms. She had electronic monitoring, and this was also a highly publicized case of the Manatee. Again, bond granted on the second degree, and that involved a firearm. We also have the next case, Marcia Thompson. I believe she was a correctional officer who she emptied her, I think 5 times, shot her husband, longtime husband. And in this particular case, I believe the defense, well, I don't believe, I know, but she was granted bond. House arrest with a monitor. Bond was set in the amount of $250,000. No firearms, other standard conditions, right? Surrender passport, right? It's something that the state wants or believes that she, according to a flight risk, will surrender her passport. In the Marcia Thompson case, by the way, the defense, the second-degree murder, the defense hired not Dr. Lenore Walker, but a different one. I think the state's expert, or intended expert in this case. And Marcia Thompson was acquitted by a jury. I'm not familiar with the facts, but apparently it was long-term abuse by her husband. So, Judge, to sum it up, we do have the new evidence, the Dr. Malad Webb report. We have her new financial condition, which the state said I didn't have any documents, which now we do, and I'll get some more. But the calculus has changed significantly, and I believe the court is not sitting in appellate capacity, but I believe this new evidence provides the court sufficient information, and of course, you have to look at everything in this case, but I think that there's a significant basis for the court to grant bond on this matter.
Thank you, Mr. Chair. Mr. Avenant?
Yes, Judge. So, the basic premise for why we're in front of the court, Judge, is 907.0441, 5K, and for criminal procedure 3.132M, both require either a subsequent event or new information that has materially altered the circumstances that justify the detention. Judge Cruz sat in your capacity right now, Your Honor, on this exact case on 2 separate instances and has heard all of this evidence except for 3 things. And then the 3 things are Dr. Webb's deposition, or her report, I should say, this financial situation, and the motion that we just heard before, Your Honor. Defense brings up potentially a 4th one, but I believe it was handled by Judge Cruz about this misconduct. And I'll start with that just to address it. When it comes to, Your Honor, and not sitting as an appellate in an appellate capacity, you look to Judge Cruz's findings of fact, and there are very specific findings of fact. When Judge Cruz ordered the defendant to be held at the first Arthur hearing, Judge Cruz stated, "The defendant has millions of dollars at her disposal and the ability to make more outside of the jurisdiction of the United States." That still hasn't changed. Defense calls it a laughable situation, but that is a reality. And it's a fact found by this court. The state is correct that the defendant's criminal history in previous cases show the defendant did not abide by the terms of her pretrial release conditions, at the very least picking up new cases when out on bond. That's a finding of fact by the court. Defense talks about this affidavit. That was before Judge Cruz in making that finding of fact. In those cases, the defendant was facing little jail time and still did not abide by the court's orders. The court is concerned about what the defendant might do when faced with the possibility of life in prison, which is what she faces here. The court does not agree that placing the defendant on house arrest with her parents in Texas is an appropriate form of release in this case. Defense came before this court, the first instance, the second instance, and today, asking for the same thing that they're asking this court to do, and to send her back to Texas. They bring up this ankle monitor, or this house arrest monitoring system. Your Honor has handled a number of these situations, and it's very clear that these companies do not notify the state attorney's office, do not notify local police when someone cuts off their monitor. You have to continuously reach out as a prosecutor's office or police department to get updates as to what is actually happening and how this person is being managed. When it comes down to culpability, so Judge Cruz made a finding of fact in the first Arthur hearing and pretrial detention hearing, finding the defendant's credibility questionable, and questioned it throughout about her flinging the knife and how she threw the knife. Defense put forward Dr. Maroncini's testimony. He testified in that the next hearing, and this video about how it's possible that she could have flung the knife. Again, that did not persuade Judge Cruz as to her initial finding of fact, that the defendant's statement lacked credibility. They now talk about Dr. Millard Webb's report that, and really all they quoted it for was to support this timing component about not letting the victim bleed out. Judge, that does nothing to the very specific finding of fact that Dr. Webb found in agreeing with Dr. Hutchins, the state's medical examiner, that the trajectory and the depth of the sharp force injury is most consistent with a stab wound. Again, Judge, that is second-degree murder. So the state's argument has never been because she let the victim bleed out, this is a second-degree murder. No, she stabbed the victim, it's second-degree murder. Everything that has been presented, being the knife-throwing expert, all this prior information, are things that this court, one, should not reconsider, but was considered by Judge Cruz in continuing to hold the defendant. And again, nothing that Dr. Webb's report, or what's in Dr. Webb's report, changes, or should change, the defendant's culpability, the view of culpability, should do nothing as concerning flight or danger to the community. So, the argument here, this danger to the community argument that, now that the only person that would be a danger to the victim, was also made at the first and the second motion for pretrial detention. So this is also nothing new. It was considered by Judge Cruz, and it had no weight. The defendant is a flight risk. It's clear that she did move all of this money into her father's accounts. What's not provided in those documents is his accounting. And so, certainly her bank account has nothing in it because it had nothing in it within a month of this case when she funneled this money into her father's account. When it comes down to the ability of the defendant to act in a certain way, the facts of the case matter. She's facing life in prison, Judge. There really is no other way to sugarcoat this. That is, you come out in a pine box. And that Judge Cruz wrote in here, the fact that that is over her head was so concerning to Judge Cruz that she put it in her order. That's not something judges normally do. It was considerable because of how much what would become Williams rule evidence, but what was put forward in front of Judge Cruz in that initial ARCA hearing. So when it comes down to the new evidence being that the defendant is broke, that won't stop her from fleeing if she wants to. When it comes down to the danger of the community, nothing additional that the defense has brought forward, those 3 items, has nothing to do with danger to the community and should not change. And then when it comes to culpability, that has not changed. When it comes to this delay that the defense points to, and they say it's attributable to the state, Judge, that was their decision. I spoke with the defense on numerous occasions about moving forward with certain work on this case. They had their motion to disqualify our office. They chose for 18 months to not take a single deposition, even if Mr. Quinn was not sitting in those or partaking in them. They chose not to. So they now want to use that as a sword and a shield to say, she's been held longer than she should have because of the situation that was before. We're now in a situation where Your Honor has the case. There's no reason for delay. There's nothing before this court that should delay this any further. The defense has filed a number of their motions. I think we have deadlines on a number of responses and when we're going to litigate those items. There's no reason for this case to not be expedited. So it should not be viewed as the state's fault for this delay. But even then, this is not a case that at least we anticipate is going to be litigated far into the future, especially not from any sort of delay by the state. So at this point, Judge, this is now the 3rd chance, and now before Your Honor, the first that you're going to hear some of this evidence. But Judge Cruz made specific findings. I don't believe any of this is persuasive to have the defendant's status change, and that's the argument.
Thank you. Mr. Grego?
Just to kind of try to take that in reverse order. Of course, the new evidence goes to culpability because it goes to whether this is a second or manslaughter. You've heard my arguments on that. So yes, it's absolutely a change in the court's calculus. The government saying it's the defense's fault for not conducting discovery during the 18-month period, that argument carries, quite honestly, no weight because the depth of the breach into the attorney-client privilege and work product privilege was not known until we had Mr. Abahoff, until Mr. Quinn's deposition was taken, and it appeared from his deposition testimony that all the privileged materials did not make its way into the VK system, and that he did not disseminate privileged information to Mr. Abahoff and Ms. Hogue, my former supervisor, sorry, Ms. Hogue. And then we put Mr. Abahoff and Ms. Hogue under oath, Judge Cruz did, and had them affirm that statement that I made, that they did not receive it. So until the defense knew the depth of the penetration into the attorney work product and client privilege, no way were we going to take discovery with potential prosecutors that were tainted.
Can you refresh my recollection as to the date that Judge Cruz conducted that inquiry of Mr. Abahoff and Ms. Hogue?
It's on the docket, Judge, on the jacket.
Melissa?
What month?
Yes.
Yeah, the deposition.
It's page 9.
My memory wants to say April 19th. I don't know.
I had looked at that yesterday. I think it's page 9.
shortly thereafter, we started setting depositions with the state, but we were not going to conduct any discovery, any significant discovery.
And while she's looking for that, and I'm pretty sure that I asked this question before, how many more depositions or how much more discovery do you anticipate that you need to do as of today?
Significant, but quick. The lead detective, quite honestly, didn't do much. His depositions are not going to be very involved. The deposition of the medical examiner, again, we have our expert who's been deposed.
The neighbors, we've been waiting for the state
Judge,
to
yeah,
give us
let me-
the updated
Just,
address.
sorry to cut you off. But yeah, let me back up that talking about delays, just to inform the court, Mr. Abahoff on Friday emailed the defense team that he could not make the Friday deadline to get the updated witness, to confirm the witness, civilian witness addresses. He asked for an extension till Wednesday. I emailed him back immediately saying, hey, no problem. Today is Thursday, and we still don't have any.
They will have that today, Judge. I meant to send that yesterday.
Melissa, any information?
They were sworn in on April 30, 2025.
Okay, thank you. I didn't mean to derail you, but I...
No problem, Judge.
Obviously, I came into the division in July, so I was...
Right. So about 3 months or
Yeah.
2 months before you came in.
Okay, go ahead.
I'm sorry. So still continuing kind of reverse order. He's saying Dr. Webb's findings are exactly that of their expert ME or their medical examiner. Dr. Webb opined did not make any opinions, and he was asked about it. He had no opinion of whether the knife was thrown or whether it was a stab, like a face. It's a little confusing to say, because a lot of people say stabbing. All he said was that the manner or the means was a sharp force. I forget the exact term. He agreed with the state's ME on that, but he had no opinion about whether the knife was thrown or not. And he also has no experience with knife throwing, as does our ME by happenstance. It happens that he's a novice knife thrower. But so that what the state said is incorrect. And that's not really common. Judge, with that said, I believe Mr. Puglisi has a couple of points that she wanted to make.
Judge, I think that the state is minimizing the testimony of Dr. Webb here, and that's obviously logical on their part. But his argument was that she's charged with second-degree murder because he was stabbed. However, at the Arthur hearing, when you look, timing was a big issue. They made a big deal about the timing. And that's why Dr. Webb's testimony here makes a big deal, because it is the difference between a second degree and a manslaughter. And as far as the delay, sword and shield, the reason we couldn't move forward, Judge, not just because of the discovery, obviously that was important, but because had we not filed the motion to recuse and moved forward with that and actually done investigation and discovery, we would have waived any appellate issue we had on that. Clearly, there's no question there was misconduct. It was obvious we had to file motions to recuse, and in order to do that, the delay had to happen, or we could have waived that appellate issue. So that's the reason that we did nothing. And obviously, the fact that as soon as those motions were resolved, we immediately started setting depositions and doing what was necessary to move this case forward as fast as possible. And finally, I would just say, with respect to the bracelet that Mr. Adamhoff discusses, it's people take them off. We know we've had these issues for many years, but I was just advised by somebody much smarter than me, Mr. Facciadomo, who keeps up on all the new statutes and everything. He says that there is a new statute that says if you actually cut a bracelet off, you will be facing a new charge at the same level of the charge that you're currently facing. And so it obviously is a great incentive for people not to do that, and I think that that is a reason to show why Ms. Clenney would not remove the bracelet.
Anything from the
Judge, it just, obviously Ms. Puglisi and Facciadomo are both smarter than me, but I would say when Ms. Puglisi said, so that's why we did nothing but file the motions to depose ASAs, nothing, and we could, and recusal and whatnot. So we were focused on that, and again, as we think it through, yes, that would have waived a lot of our rights on appeal. So that's why, quote unquote, nothing was done.
All right. So those were the two motions that we were intending to address today, yes?
Correct.
Okay. Very good. I would like to take a recess and reconvene at noon. Okay? So, thank you, everyone. Please be seated.
That's what they're.
And they've moved
I see.
on appeal, right, to
Okay, now back on the record in the case of the State of Florida versus Courtney Clenney, noting the presence of the Assistant State Attorney as well as Ms. Clenney and her defense counsel. First, I want to thank everyone for your level of preparation in reference to the arguments that were presented today. The court has reviewed all of the written pleadings in the case, and I'm prepared to rule, although I will supplement with likely some written orders. First and foremost, as to the defendant's motion to dismiss information based on repeated government misconduct and for destruction of evidence pursuant to Brady and Youngblood, the court is respectfully denying that without an evidentiary hearing. The court finds that has not made a showing of bad faith in that law enforcement or prosecutors intentionally destroyed evidence they believe would exonerate the defendant as required by Arizona versus Youngblood and its progeny, and I will cite some Florida cases for the record as well. As far as the defendant's second amended motion for reconsideration of bond, the court does not believe there has been a subsequent event or new information that would materially alter the prior ruling from Judge Cruz pursuant to 907-415K and Florida Code of Criminal Procedure 3.132M, and that motion is also respectfully denied at this time. I would like to talk about prioritizing the path toward trial within the first 3 months of the new year. What, if any, impediments does the state see with planning for that?
So, Judge, I have 2 events that I'm going to leave out of town for Fridays only in March.
Okay.
Your Honor, the dates, and even then, one of them I may not need to go.
Okay.
That being said, I think we have either 4 or 5 no further trials. So I think we all, Your Honor's schedule and my schedule, either moving some of them to make room for this case or maybe prioritizing this case for April. Okay. Which I don't think we have a final.
Say that one more time.
I don't think we have any cases set no furthers in April.
The ones, and I left my other paper in chambers, the ones that are set no furthers in January, February, and March, are they older than Ms. Clenney's case?
We have one that is older, one that is the same year, and I'm not sure. One is the same year, and I'm not sure which one is older than the other, but relatively the same. And then the others are either a year or 2 years old.
Okay. Before I ask the defense the same question, I'm going to figure out one thing. so same question for the defense, and let me hone in on one possibility. April 6th being a firm trial date. What do you think?
Just give me one moment, just I'm out of town, it may be.
I don't know if it matters to anyone else, but April 5th is Easter Sunday. That may pose a problem. I'm trying to
Because
figure
my
out-
child goes to Catholic school,
Right.
which means that she gets that whole week after.
Is it for sure the week
Yes,
after? and
it's
not
Holy
the week
Thursday, Good Friday, and then the whole week after.
Okay. So-
That's what I was kind of looking.
Yeah, I know, and sometimes it's on the front end, and sometimes it's on the
Yeah,
back
no,
end.
they always do it the week after Easter.
Okay,
Judge, I'm out of town, returning the 25th of March,
Of March.
which does not realistically give Ms. Puglisi and I enough time to prep. for
what
that.
about an April 27th trial date?
I think that that's a lot more reasonable.
That's perfect.
Okay. Mr. Ackerman?
So Judge, that should be okay. I don't foresee this case going 2 whole weeks. One of my May events, I have an event in May, that's it.
Well, we could take a Friday off, that's fine.
Okay.
I mean, obviously, the case is going to take some time, there's quite a bit of moving parts, so, you know, if we needed to suspend on a Friday and come back on a Monday, that's not going to be an issue.
Okay.
Does the state have an estimate of how long you think the state's case would take about? I mean, I was thinking 2 weeks more or less for the whole thing, but.
I can't foresee it going longer than 2 weeks. I mean, the state's case, I think we're finished before the end of the week.
Okay.
We're happy to have a date certain, Judge, so we will be
Yeah.
ready.
Okay, that's what I would like to do. Then, we need to circle back to the list. What about the bill of particulars?
So Judge, at this time, the state announced there's no process at count 2.
Okay, all right. So,
Michelle, we appreciate it. Thank you for your professionalism in dealing with that.
that makes moot the bill of particulars.
It would move my motion, correct, Judge?
All right, so that's the night is moot. And that leaves us with the, I'm not able to read my notes accurately right now, and I don't have it in front of me. Which recording was the motion to suppress based on?
It's various recordings.
Okay.
It's various recordings, they're delineated in the motion.
Okay.
Right, I
Does
think
the court
mine,
have a copy of them on a hard drive though, or on a
No, I'd have to
USB?
provide that.
We'll provide you with the specific recordings, Judge, so that you have them.
Okay.
just
Mr.
a second.
Ackerman?
I need to respond, Judge. I think you gave me a cutoff date of either the 9th or the 16th. And then, I don't remember which one. I don't have it.
The 9th for the motion to suppress and the 16th for the motion to compel, 404.
Okay, okay.
Okay. So I think it would be appropriate to have a report date sometime after the 16th of January. Carlos is in here and my calendar is in chamber. So what's a date on like a Tuesday after the 16th?
The 20th, Judge. 120.
Or the 21st?
Tuesday the 20th.
Tuesday the 20th.
Because it's right after Martin Luther King weekend. Okay. All right. So January 20th, I'd like for us to reconvene for status. And then officially, it will be a 416, 427 sounding in trial. I think that's pretty much all we can
Yeah.
accommodate at this point. Mr. Abdullah, anything further on behalf of the state?
The only 2 things, Judge, I'm looking through a lot of the file. I know defense has provided in multiple hearings different items of discovery for the hearings. I'm not sure exactly if they've already provided us or if they have provided Mr. Quinnen defense discovery or evidence they hope to present in trial. I just asked for maybe a courtesy copy of that so I can review it. And then I know that in today's hearing, there's a number of events that lead up to the homicide. There's there's actions on both parties, and I think the defense wants to go into a weird filing of a Williams rule motion. I just wonder whether the defense will be filing a reverse Williams rule, or we're going to be litigating those types of issues rather than as like a motion in the meeting.
Have you contemplated that, or do you need more time to strategize?
No, I obviously will be opposing the state's Williams rule. We need to take the depositions of the 404s to determine whether or not those will contribute to grounds for a reverse Williams rule, and we need to consult with Dr. Walker on that as well. So I think that should be litigated pre-trial, not.
Oh, yeah, right, we won't do like a
the
motion
jury
in the
standing
meeting,
out.
like, yes, like, it won't be like that, we understand.
And the other thing that occurs to me that, I believe this in all cases, but certainly in cases involving discovery, that it would be prudent for you all to have a joint pretrial conference to go through all of the files and make sure everyone has all the
Yeah,
stuff.
the electronic evidence in this case is.
Yeah, I mean,
Insane.
sit at a conference table, with your computers and make sure that everybody's on the same page.
Right, we'll try to streamline it as much as possible, Judge, and go over and let them know what we object to or what we do not object to, so that we can make introduction of evidence much simpler.
Perfect. Okay.
Judge, I don't know if it's possible. Because we're so far in advance, is it possible, because of how many people and the attention that this case is getting, to maybe reserve 4-1?
Yeah.
Yeah, I can ask for that. Yeah.
I just think, I have a feeling that it might be necessary, especially with a jury.
Yeah, we'll do that. Yeah, so let's have Janet for the week of 4/27.
It's probably going to be about 2 weeks,
Yeah.
just in case.
Yeah.
How many jurors?
We'll figure that out. All right. Thank you so much. Everyone have happy holidays, and we'll be back January 20th.
Thank you, Judge, you too.
All right, so that concludes that hearing. So what we got out of that was judge denied both motions. So she denied the motion for bond, and she denied what was the other thing she denied? The big one was hold on a sec. Yeah, it was, she denied bond. That's what it was. They tried to, they were talking, initially they talked about this video that came in, or that was reportedly taken by one of the security or staff at the building where this event happened. And then the state doesn't expect this going more than 2 weeks for them. So the defense, maybe a week if they put on a case. So this could be a quick trial, and it's April 27th. So we have Sarah Grace Patrick on January 5th. We got Corey Richens, February 23rd. We got Courtney Clenney now, April 27th. We've got Shauna Gardner potentially in August. Got a lot of big trials. We have a lot of big trials. Yep, no bail. She was denied bail. She was denied bail. Still no bail. Yep. So, all right. Alexa, yes, have a happy birthday. Enjoy your weekend. All right, what do you guys think? What do you guys think of what you heard today? I think, well, you guys think about that and post in there. What do you guys think? Hold on, I got it. I'm getting blasted by this here. Okay, there. That's a little bit better. What's up? All right, Erin just reminded me that she scheduled a premiere for Carlos Dominguez's hearing. That was yesterday. And how long is it? Like a half hour? No, 6 minutes. Oh, yeah, it's like a 6 minute. So Erin scheduled a premiere if you guys want to go check that out. Should we? You can't chat on it, right? You can chat? All right. we'll set up a redirect. I'm not going to be on camera, but if you guys want to watch the latest with Carlos, yeah, Carlos was supposed to be January, but that got now pushed to March. So, so Carlos is in March. Well, we don't have a date yet, so I'm not going to put him down. But is it official? Or we don't know. Yeah, it could be pushed down. So Corey Richins is February 23rd. February 23rd is Corey Richins. So this one reminds me so much of Amber Heard and Johnny Depp. Like, when I first saw them squabbling and Christian is like, let me in, you hit me so hard, I'm bleeding still, I'm dizzy, I'm woozy, let me back in, open the door, and then seeing the videos of her just berating him and the elevator where she's like punching him, and I'm like, geez, this is so much like Amber and Johnny. I'm like, Johnny was lucky he got out alive. Christian not so much. So too just terrible. Feel sorry for him. So, and I've seen more evidence of her being, aggressive to Christian. Like Christian, that elevator one is really pretty powerful. Where I think we counted 20 or 30 times where she punches him, and she's like punching him in the head. She's grabbing at his hair, and he's like pushing her back. I mean, he's defending himself. I mean, at some point you have to be like, stop it. You can't just sit there and just take it as much as you don't want to hurt, you don't want to hurt a female, obviously, because he's a big guy, he's a big dude. But it seemed like he was pretty restrained. He could have very easily clocked her and knocked her on her butt, But he didn't, as far as we know. Yeah, David, Amber Heard. I'm seeing so much parallels. So many parallels between Amber and Courtney here. She's like a Amber. What Psychosaurus? What did you call her? A Amber wannabe, or what was you said something earlier? It was a toxic relationship. Yep, for sure. I'm gonna ban you every day. No, he should have left her. Yeah, Kathy, it's one of those cases. Shoulda, woulda, coulda. Maybe he was trying to. Who knows? Joyce, Amber and Courtney must be related somehow. They're both from Texas. She's, I think, from Austin, maybe, and Courtney, I forget where she's from, but I know she's from Texas. Knock off Amber Heard. There you go. Knock off Amber Heard. Jenny Lynn, yes. Well, we're just wrapping up here. But glad that you made it. Glad you made it home okay. Play on crime. Yeah, you're with me. So we have some really good trials coming up. Some really big, like high profile trials. Corey, Courtney, Shauna. Those are some pretty big trials. So, all right. So I'm going to say goodbye for now. I hear some activity behind me. What's going on behind me? What's up there? Got some craziness going on. Oh, you're going to see just a paw come through. That's a little Sid up there being a little crazy Sid. So, all right. So with that, have a great weekend. We are not going to be streaming this weekend. We are going to take off this weekend. And next week, gosh, we have to figure out what we're going to do next week. Shonda Vander Ark. We're gonna rewatch Shonda Vander Ark. I've always wanted to see that trial. I've never watched it. So we're going to do Shonda Vander Ark because the Ian Mitchum trial they're not streaming it anymore. So we're not gonna if they ever come back online, we'll cover it. But for now, it looks like Shonda. What? Who? Rafa's got a mole or rat? Oh, great. So. Yeah, Grampy, I wish I could show you Super Ball, but she oop, hold on. Birdie. I want to pull this up. There. She's upstairs. That's her new place to hang out. Although she was hanging out on the window here for a while. So, well, you got that activity back there. So, all right, Barry, thank you for the gifted Trial TV Live gifted memberships. Grampy, thank you for the Trial TV Live gifted memberships. For those that did give super chats, we saw those, we acknowledge those, and we thank you for those. And with that, have a great weekend. If you want to watch the Carlos trial hearing, I should say, it's like only 5 minutes. It's pretty quick. But we have that premiering in a few minutes. And with that, thank you to our mods. Thank you to Aaron, who is right here beside me. But
I think the rat's headless.
oh, Rafa has a headless rat. Rafa made the rat headless.
I think
Yeah.
it's pretty big.
Ooh, all right. I'm going to go have to investigate that. All right, guys. Have a great weekend. We will see you Monday. Shanda van der Ark. I know it's a tough trial, but I never saw it, and I want to see it. And we're going to watch that. Okay. So have a good one. Enjoy. Take care of yourselves, and we will see you Monday.